Good afternoon, and welcome to a webinar on becoming a sought-after expert witness, hosted by EAS Consulting Group and presented by Ronald Levine, General Counsel at Herrick Feinstein, an independent consultant for EAS, and his colleague at Herrick Feinstein, Leah Kelman. EAS specializes in FDA regulatory solutions, working with some of the industry's most pressing challenges and offering over 150 regulatory consultants, 70 of whom act in an expert witness capacity for legal proceedings. Herrick Feinstein is a private law firm providing a full range of legal services to businesses and clients around the world. With offices in New York City, Newark, and Istanbul, Turkey, Herrick is active in defending food and beverage class actions, an area in which Ron and Leah practice in. Our presenters today are Ron Levine and Leah Kelman. Ron Levine is an EAS independent consultant and general counsel with Herrick Feinstein and has over 40 years of experience advising and representing consumer product companies in complex legal matters. His team plays an integral part in developing their clients' marketing and crisis prevention strategies, helping them identify and address compliance issues that affect their products and brands. Leah Kelman is an Associate General Counsel with Herrick Feinstein and a litigation attorney. Leah concentrates her practice on complex commercial litigation, including class action defense, regulatory matters, and professional responsibility, ethics, and risk management. As a reminder today, during the webinar, you may ask any questions by typing them into the questions box. And with that, I will say thank you again for joining us, and I'll turn the presentation over to Ron and Leah.
Thank you very much. Good afternoon. This is Ron Levine, and I want to welcome you to this Expert Witness Bootcamp webinar. We're calling it a bootcamp. So I hope you enjoy it. I want to first thank EAS Consulting for organizing and hosting the program. And I want to thank my colleague, Leah Kelman, for her assistance. She'll be joining me later in the webinar. And I really want to thank everyone who's participating in this webinar and listening for your interest. Please note that our comments are our personal thoughts, and we're not meant to provide the position of either EAS or our law firm, and we're not meant to provide any legal guidance or advice. I'm assuming that we have audience members who have never served as an expert witness, as well as those with experience, and that's the way we've approached this. We've tried to provide a presentation that anyone with experience or not might find helpful. A boot camp, which is what we titled this, is defined as a short, intensive, and rigorous course of training. That's the plan, to stay focused, to try to hit the major points, and to move as quickly as possible. If you're interested in a deeper dive into training as an expert witness, we're hoping to perhaps do a full-day program, which you may want to consider. You heard a little bit about myself. I've been practicing as a litigator in private practice for more than 40 years. I've concentrated in class actions, especially food and cosmetic, and I also do product liability. I've been involved in some fairly well-known cases, including Ford Firestone, tobacco, and more recently has been the food and cosmetic labeling class actions. I've been with my current law firm, Herrick Feinstein, for more than 35 years, and I chaired the litigation department for 15 of those years. I've also been serving as an independent consultant for EAS, providing consulting on crisis management, labeling, FDA, and regulatory matters. The reason for this webinar is that in working with my clients in all different types of cases, whether they are FDA or automotive, I work with expert witnesses. And I thought it would be a terrific idea to present a program which the expert witnesses I have worked with, I wish they had taken sort of a little course, and it would have saved me a lot of time for some of the experts I've worked with if they had gotten a little training in how to be a better expert witness. Great expert witness is usually not a lawyer, but a great expert witness can make all the difference whether or not I succeed in my cases. Success can mean a jury verdict in my client's favor. It could also mean a good settlement. More than 90% of all civil cases never get tried. They get resolved in pretrial motions or settled, but expert witnesses can provide important advice and testimony pretrial that can make all the contribution to a settlement. So being an expert is not just about trial testimony, it's about a lot more. In this presentation, we've tried to distill the best practices we have observed, having worked with many expert witnesses. So there are very, very few guidebooks for expert witnesses, and universities don't offer a degree in becoming an expert witness. And there's no specific license or exam required to be an expert witness, which is pretty interesting. It's ultimately up to the court, as you'll hear later, as to whether or not you'll be qualified to testify as an expert witness if you get on the witness stand. And almost anyone can try to be an expert witness with or without advanced degrees if the person can claim a special expertise. So we are intentionally not limiting our comments to being an FDA or cosmetic or a drug expert. The same rules and advice would apply to an FDA expert or to a nuclear scientist. And I have distilled in this presentation with Leah the guidelines and qualities that we think any expert needs to have, and we hope this may be helpful for you. And those who are serving as experts may find some of this helpful in refreshing your recollection of some of the things that have worked and not worked. So what are we going to try to cover? In this slide, we're going to be going over the, as we say here, the role of an expert witness. I am assuming that everyone participating in this webinar is an expert on various topics or fields, whether or not they've been an expert or not in the actual litigation. We're going to try to help you decide whether or not you can serve as an expert witness if you haven't served as one before, and whether it'd be a good fit for you. Just because you're an expert on something doesn't mean you're cut out to serve as an expert witness. We're going to give you some thoughts on how to attract additional assignments. We're going to give you our thoughts on how to approach a potential assignment and what you may be asked to do. And most importantly, we're going to share our thoughts on how you can do a good job and hopefully attract more assignments and make lawyers such as Leah and me happy that we hired you. Slide 5, please. Let me begin by urging you to serve as an expert witness only if you think you'd enjoy doing it. If I were administering an occupational test for experts, I'd be looking for individuals who like to teach, who enjoy doing research and solving puzzles, and who like to talk. Hopefully that applies to many, if not everyone. I would want people with a great deal of patience and who don't get easily rattled. If you have a short fuse, you could get into a lot of trouble as an expert. Even though you're going to wear the title of expert, you need a certain level of humility. I want someone, and I want you to be confident in your opinions. I suggest you keep your day jobs, since most expert witnesses are not professional experts. They stay on top of the fields through work they conduct as professors, researchers, or consultants. Indeed, having a day job and a career other than serving as a witness can help enhance your credibility as an expert. As I mentioned here, you'll be doing much more than merely expressing an opinion as an expert. You're going to investigate, review, and assess a set of facts in addition to expressing opinions. Slide 6, please. The reason that the legal system has made room for experts is because there's a recognition that there are some issues which a jury or the judge, that's the ultimate decider, is simply not qualified to assess. For example, the jury could look at a photograph of a house that burned down and conclude that a fire caused the loss. That would be reasonable for anybody in the population to do. But a jury could not know what actually caused the fire, nor could any just an average citizen know that? Was it an electrical short? Was it a cigarette? The jury needs to hear from an expert on arson in this case to explain what happened. The arson expert would need to explain what needs to be done to figure out the root cause of a house fire. Because of that arson expert's special background and experience, they would be qualified to tell a jury what happened, and they couldn't just call a neighbor to explain what happened. But before that arson expert gets in front of the jury, the arson expert has to convince the judge that that arson expert has the background and experience to testify. The judge is the sort of the gatekeeper for the expert, which we'll be talking about later. So I do make reference here to alphabet experts. It's expression I use. It's an expert on everything from apples to zebras, but the person who's really not an expert on anything. One of the casualties of the expert business are alphabet experts. You can see them in the newspapers. They advertise that they'll testify to anything. This is not a career I recommend. These are guns for hire who will say whatever needs to be said. For that reason, and we'll be talking about alphabet experts later, my recommendation would be to keep your focus as narrow as possible. Your credibility will be enhanced if you don't come across as someone who will talk about anything for $1. Slide 7, please. So this is what makes a great expert, and I hope you enjoy the Saturday Night Live superstar. So I want everyone on this call to be a superstar. Let's pretend that Lawyer Jones calls me and she says that she is considering retaining Dr. Wilson. Okay, Dr. Wilson as an expert. She asked whether Dr. Wilson is a good expert. And she heard that I have used Dr. Wilson in the past. What would prompt me to tell this lawyer that Dr. Wilson is someone she should interview and possibly hire? What are the qualities I value most? Well, I gave it some thought, and my first quality is was Dr. Wilson available? And in the legal business, we have deadlines. An expert who cannot appear for an examination, who does not get me a report in on time, is a disaster. I can put my client at a real disadvantage if I miss an expert deadline. Expert report that comes in after the deadline can be thrown in the garbage. So I do appreciate that some of you like to travel, as I do, and leave your computers at home. I am not going to be very happy if I hear that my expert's on a 4-week cruise and totally out of pocket when I have a report due in 2 weeks. So no report is the worst disaster. So number 1 is being available. Number 2 is, did Dr. Wilson understand my job was to represent my client? I had a case involving some equipment. I was representing the manufacturer, and there was a claim that a control on the equipment was defective. So I retained an expert on the controls, and this expert spent weeks studying the machinery and reviewing the entire file. And I thought this was great, and he was very thorough and spent a lot of time, and I got a couple of bills from him. And finally, the expert got around to sending me his report. And guess what? He told me that the equipment was defective. Well, that was I was trying to prove the equipment wasn't defective. So thank you very much, Mr. Expert. And what really galled me is he told me that he knew that from the very beginning, but wanted to spend time looking at everything. Needless to say, I decided not to call that witness. I was not very popular with my client, having sent some significant bills and finding out from the expert that I couldn't use the expert. So if you generally don't think you can be helpful, I would decline the assignment, and you're not going to be very popular if you take on a matter and later, and kind of just hold it close to the vest and don't tell the lawyer you're working with that maybe you can't be the best expert for that lawyer. Now, the third set of qualities, and this goes to what more in the slide here, is did Dr. Wilson speak well, look the part, and was Dr. Wilson able to explain his position to the jury in a manner which they could understand. Jurors relate to expert witnesses in a manner similar to the way they related to their elementary school teacher. If the expert's unclear, talks too fast, or is unpleasant, the juror could have bad flashbacks to a teacher they despised in third grade. Lawyers want experts who can relate to third graders and make them feel comfortable. So that's what I'm looking for. I'm someone who the jury's going to sit back, and they've been sitting there all day in that chair and smile to themselves, say, "Oh, this is going to be an okay experience. Listening to this person, I understand them. They sound confident. They remind me of people I've liked in the past, and I'm all ears to hear what they have to say." Slide 8. Okay, so you're sort of on the fence about whether or not you want to be an expert witness. Well, here's my pitch on what are the benefits of being an expert witness. It can be interesting and challenging work. You're going to take advantage of special knowledge and experience. One of the reasons I like what I've done for the last 40 years is the variety. Every case is a new challenge with its own unique set of facts and legal issues. You'll probably not be issuing boilerplate expert reports. In fact, that's a bad idea. You need to approach each case with a fresh eye and an open mind. The work can result in significant fees, but keep in mind you're probably going to be paid by the hour, so your earnings will be limited to essentially the amount of time you're willing to devote to the matter. Now, I want to be clear, you could always be hired by a company as a consultant and not be considered an expert witness or even a consulting witness. Clients hire pure consultants all the time to deal with product development, claims, and projects. An expert witness is someone whether or not as a consulting or someone who's going to testify who's involved in the legal process. And that's when we call someone in as an expert witness. So I just want to be clear about that, because I know many of the people on this phone do consulting work and say, what is he talking about? I am an expert witness. Often the end product for an expert witness is an expert report, which we'll be talking about in a little while, which may be presented to the court in the legal proceeding. Slide 9. So these are the qualities which would serve you well as an expert. So these should come as no surprise based on the themes, but it's a good summary. Creative mind, good communicator, you're patient, you can teach, and you're careful, and you pay close attention to details. Slide 10. So are you an expert? The dictionary defines an expert as one with special skill or knowledge representing mastery of a particular subject. I suggest you consider, if you're thinking about being an expert witness, what objective factors you would cite to support your belief that you are an expert. Do you have special education? What are your licenses? I just want to highlight here on licenses that they can be specific to a state. If you are only licensed as an engineer in Ohio, you may have problems serving as an expert on a New York problem. So licenses can be very specific if someone's sort of being very technical about the expert. Are there special accreditations? What's your employment history? Have you done studies? Have you written articles or books? Have you lectured? All of these factors and others are going to support your position that you're an expert. There is no test, and I have used experts in cases who didn't even have a college degree, but had so much employment experience and life experience in a certain field that they qualified as an expert. So you don't need a PhD to be an expert. Depends on, in your field, what is considered to be the skill set. There is no PhD, for example, in being, to my knowledge, to being a plumber who works every day out in the field. Often they don't get PhDs, but I might want a plumber expert in a case involving a plumbing failure. So, and that would be someone with a tremendous amount of experience working in the plumbing field, who's seen all kinds of problems, has gotten perhaps on-the-job training and courses, and someone who possibly has been called in by authorities and agents to deal with plumbing problems. That would help a lot. So now we're up to slide 11. Now, not every expert is going to be helpful in a legal process setting. There has to be obviously a need for the expertise. It's going to be up to the lawyer who's defending the case or the company's in-house counsel whether or not what kind of expertise they need. In the food and cosmetics world, we need all sorts of experts, and I have to be honest, it hasn't been easy sometimes finding them. First of all, we need someone who's willing to testify and serve as an expert witness. And that's, a lot of people don't want to take the time out, or they're concerned about taking a position officially in a case, so they've been reluctant. But we're looking for people with experience in best practices, ingredients, statistics, marketing, labeling, contamination issues, you name it. For example, recently with a large number of cases involving natural claims, we've been looking for experts who can testify whether a specific ingredient, such as, for example, citric acid, is natural or not. We have clients who have put the word natural on their label, and plaintiffs have challenged that. And one of the ingredients, for example, is citric acid, which sometimes has sort of as I'm sure people on this phone know, could have a natural base, and sometimes it's questionable. Same with the word GMO or non-GMO. So these are all areas where we could use expertise. We've gone to universities, we've gone to former laboratory people from companies, research people looking for experts. If you do have expertise, and what role are you going to play? Well, there are a number of potential projects for you. You could advise on technical issues. You could help develop strategy for prosecuting or defending a case. You could review claims or defenses before they're filed, and you could help develop questions for the lawyers for discovery and help answer questions from the other side. So it's not just going to be sitting on a witness stand. You could play a very active role with the lawyer in helping to mold the case. At this point, I'm going to turn the presentation over to Leah, and she's going to take you through some slides.
Next slide. Good afternoon, everyone. I'm very happy to be here. On this slide, we have a brief primer of the U.S. legal system. So there are many opportunities for experts in United States proceedings. We litigate in state and federal court, as well as before federal, state, or local, or even very local, like town or county agencies. There are also private dispute resolution organizations, such as the American Arbitration Association, where a dispute may be litigated and hopefully resolved. We also need experts in situations where a client is being investigated by an agency, such as the FDA, for example, but there's been no lawsuit filed, so it's just in that investigation stage, and an expert can be very helpful in that manner as well. Next slide, please. While we will be looking today primarily at an expert's role, through the litigation process and at trial testimony, you can have a very active role as an expert witness and never be put under oath or cross-examined. Many cases, as Ron mentioned earlier in the presentation, settle before a lawsuit ever gets tried. But we still need the expert to prepare and do an analysis and put a report together, and that report will help us explain how we value our case. If we're trying to settle the case, oftentimes the dueling expert reports will have very critical weight in the value that gets assigned to the case. And as mentioned earlier, over 90% of cases settle, so litigators today are not spending the bulk of their time at trial, but rather in the pre-trial stages of discovery, and ultimately expert discovery as well. Next slide, please. Not every expert in a litigation will be an expert witness. Not every expert at trial will be an expert witness. We call witnesses who are not experts all the time, and they're called lay witnesses, and sometimes they're referred to as fact witnesses. Both lay and expert witnesses can testify about the same subject matter, and often they do. This slide has two examples that highlights the difference between a lay witness and an expert witness. So, for example, the first example there, assume that there's a problem with packaging equipment and flour gets contaminated. A lay witness could be anybody who has personal knowledge of the events and who saw metal shavings in the flour. That witness can testify as to what they saw. But in most cases, only a witness who has specialized training and is qualified as an expert can testify as to the type of steel and the origin of the shavings in that flour. Before the expert will be allowed to offer that opinion, however, the expert is going to have to convince a judge that he or she has the necessary qualifications and background to offer that opinion. On the slide, you'll also see another example, lay witness versus expert witness. So you have a conveyor belt, a fact witness, a lay witness can say, based on their personal knowledge, that the conveyor belt was dirty. An expert will be able to offer, based on their specialized training, the specialized details associated with their investigation. And so here we have like that it was specifically E. coli bacteria that was found on the conveyor belt. As I mentioned earlier, before an expert opinion will be able to testify or permitted to testify on the stand, or for the expert report to be admitted and accepted, the judge will have an opportunity to decide whether or not that expert is qualified and legitimate to testify. On this point, judges are generally not interested in hearing from experts who are merely going to recite provisions of law. That's really in the judge's province to decide issues of law. But judges have allowed experts to testify about complex regulatory schemes such as approval, labeling, advertising, marketing of FDA products. For example, judges have found that a lay jury can't be expected to understand, a layperson, the common people can't be expected to understand the complex regulatory framework that sets the standard of care in the pharmaceutical industry. So in that situation, even though there's going to be a discussion of the regulations, the expert may be permitted to testify on that topic. Next slide, please. If you are in the expert witness business, you should be familiar with the two different descriptions of an expert witness, which was alluded to today as well already. A consulting expert versus a consulting witness versus a testifying witness. Many witnesses start out as a consulting expert witness, and they may later be asked to testify by the attorneys they're working with. So the major difference and the importance of the distinction is that lawyers do not have to disclose the consulting witness to their adversary, and that witness's opinions will be considered protected by the work product doctrine, will be protected from disclosure as long as that expert witness is still a consulting and only a consulting witness. However, if the witness is going to testify, at that point, the identity of the expert in the expert report must be disclosed to the other parties in the litigation. So many lawyers may designate an expert at the outset just as a consulting witness, and then once they feel comfortable that the expert is going to be helpful and they're satisfied with the expert's work, only at that point designate the expert as a testifying expert. And I'm going to turn back to Ron. Next slide, please.
Okay, we're up to slide 16, and timely because I got a question. How do I start as an expert witness? I put together my CV, and now what? So this is where the lawyer is going to go to find you. They're gonna contact consulting firms such as EAS to find candidates with that expertise. I know I need an FDA expert. I'm gonna Google, perhaps if I don't have a lot of experience with experts in the field, I'm gonna look for consulting firms and other groups that may provide folks who have background with the FDA and ask, does anyone have this sufficient background who might be able to help me? So no one may know your name, but someone may be able to identify you because you're part of a group that which you serve. So that's one way. I might contact other experts I've used who may not be available or may not be exactly in the same line of work to recommend other experts. I may look for other lawsuits involving similar claims and see what experts have been used in those cases. I may call the lawyers who worked on those lawsuits and ask them to recommend experts. I would research court records. I'd look at court opinions to see what experts the courts have cited. I would look for attachments to motion papers with expert reports to see and read their reports to see what experts have been used. There are databases that are available to lawyers in which they list experts and say what expertise they've offered, whether or not they've been qualified, and what the verdicts were. I would also look for articles which have been published on a topic, and I'd want to see who wrote them. Also, I would look at advertising. Some experts actually put up advertising for themselves. There are journals put out which in the fields in which experts can advertise. There are directories of experts and all sorts of databases. So there are many, many ways to get your name out there and to be considered. And even if you know some lawyers, you can call them up and ask them for advice on how to get it in the circuit and get your business up and running. And if anyone is looking for further advice, I'm happy to talk about it offline. Slide 17, please. So these are further examples. Here I'm giving you things to put in your resume, because if you're lucky enough to maybe get an engagement, they're going to ask to see your resume. And these are the just a checklist of what I would recommend including your resume. And this is, again, a listing under how of all the different places to market yourself. So it's endless, and it's tough, especially in the internet age, because there are thousands of experts, but there aren't thousands of good experts. And I have confidence the people who are participating in this webinar are probably some of the best. So I hope if you're not in the business, you get out there and participate. Next slide, please. This is looking at from another angle, and this is what I'm looking at. This is my checklist when I'm interviewing or considering a potential expert, and I've touched on many of these before, but just a couple of things I just want to point out that strike me as important, which you might not think about. One is prior opinions. In our internet age, your prior opinions are much more available than they were, say, 25 years ago. 25 years ago, it was kind of, I would send around letters to other lawyers and say, do you have any transcripts of this witness testifying? Because I'd like to read their transcripts to see if they said anything that might be contradictory for what they're saying in this case. Today, so if you take a position in one case, you're going to be really tough under tough cross-examination if you come up with a contradictory opinion in another case. So just keep that in mind. Another point is location. I do want to say that in this day and age, it used to be that if you had a case in New York, you were looking for an expert in New York. We throw out a wider net. Depends on the situation, the kind of case, but we recognize, for example, that there may not be experts in some of our cases in New York, and you might have to go to Washington or even California or someplace else to get a good expert. Rates are important, but truthfully, clients are paying them, and I pass the rates by the client when I'm hiring an expert. It's not as determinative sometimes as, for example, with lawyers, which is highly competitive about rates, because it's a pretty limited engagement. And if you're a good expert, there may be more flexibility. And most important, as I said, is finding out their availability and their, you know, whether or not they're going to be available. Some of these experts I've contacted say, yeah, I'm available in 6 months, and that's just not helpful. Most lawyers are calling you when they're under the gun, and they need your help. Next slide, please. So this is, we all know about the vetting process. We learned about it, for example, when a Supreme Court justice is nominated, there's the Senate will vet the candidates. Well, we as lawyers vet our experts. As I mentioned, we're going to look for your prior reports. We're going to look at not just your opinions, but your speaking engagements, your articles, your prior cases, your transcripts. We're going to be looking at it to make sure we're not going to be embarrassed with our client that we hired an expert who you know, is contradicting themselves and is killed on the witness stand. Next slide. This, if you're lucky enough to have a potential engagement and a lawyer calls to interview you, this is my checklist of suggested questions to ask the lawyer. You're going to have 2 phone calls, hopefully with a lawyer. You're going to ask them, obviously, their name, phone number, and email. But I would start off by asking who are the clients and what's the matter, especially if you have an active practice or you're engaged in a business, because you don't want to run into a conflict. The worst thing is to find out that, you know, you're engaged as an expert by an adversary, or you know something about the matter and you wouldn't qualify as an objective third-party expert. So you want to run a conflict check before you hear anything further. You may know on the phone off the top of your head, but some people in bigger companies need to run a conflict check. So these are the questions. It's interesting to find out how the lawyer got to you. You want to find out how you can help them. You want to get an idea of the schedule and whether or not you can accommodate the lawyer. Often these schedules are put off and adjourned. So if they say the trial date is in January, don't bet on it. It could be in March. So if you're planning a 6-month trip around the world, I think I would mention that up front, because experts unfortunately have to be on the call, and judges are not too interested in adjourning trials just because an expert's on a cruise. That said, sometimes experts can be videotaped in advance, and you can have your testimony memorialized and not have to show up at the trial. You want to find out, are there other experts in the case? Now, this is interesting. One of the tricks that lawyers do is if there are a limited number of experts in a field, they may go out and try to hire as many of the experts as they can to prevent their adversary from hiring the same expert. And you may never get any business, but you might just be sort of lined up by this lawyer because he just wants to disqualify you from working for the other side. So it's important to find out how many experts have been hired and whether or not you're the only expert. That whether or not you're going to be used. I wouldn't take lengthy notes. Your notes ultimately could be discoverable. And this is a really important point. Don't say, oh, yes, I know that product is not defective. That's not the way it's supposed to operate. The way it's supposed to operate is you're going to reach your conclusion after you've done a thorough investigation. So please, I don't want my expert to tell me after a 5-minute phone call what their opinion is. So I sort of, there are ways of signaling sort of a reaction, but you don't want to sort of be caught in cross-examination saying, yeah, the lawyer called me up and I told him he had a great case and this was my opinion. And it suggests that all the research and work you're going to do on the case was just cover for an opinion which you gave up front off the seat of your pants. So at this point, I'm going to ask Leah to cover the next slides.
So on the topic of conflict of interest, on this slide, you'll see some questions that may assist you, at the beginning of the engagement or when you first receive that phone call from counsel or referral, and you want to determine whether or not you're going to potentially face a conflict of interest with this potential engagement. So if you work for a company, is this a case that would conflict with your employer or your employer's interest? You might want to consider that. Do you work for a food manufacturer and you're being asked to support a false labeling claim, which could, similarly be asserted on similar issues against your company as well. So you're going to be asked to take a position on issues that could come back against your company in the future. You may want to consider that. That may be a reason you may not want to take the case. Are you already working for a party in the case? And you may be working for a party that's not a conflict, but you may be working for a party that does create a conflict. And you, like, as I just said, you can be, in the matter, working for another party that would create a conflict. But there are cases where an expert can serve jointly for parties if there's no conflict. Next slide, please. In addition to trying to avoid conflicts of interest, actual conflicts of interest, you want to stay true to yourself in your work. Put simply, don't play games with your expertise, your qualifications, the opinions. You want to play it straight in a way that's going to carry you forward into other assignments. You're involved in a very adversarial system, and hopefully you're going to be dealing with really good lawyers, and your adversary may have a very good lawyer who's going to come after you with guns blazing if you're too cute by half in a way that you've characterized your opinion or the facts of the case. So you want to be careful to avoid overstating or shading the facts or selling a false opinion that you really can't back up. So you want to maintain your integrity as an expert in every case, and that's really going to help you not only in that case, but to be well liked by the people who retained you, to be well liked by oftentimes you might impress an adversary, and that may lead to more business. So staying true to yourself and playing it straight is good advice. Next slide, please. There are a number of reasons why you may elect to turn down an engagement, no matter how much you want the business at that time. So as I mentioned in the last slide, honesty, of course, is very important. You may receive a phone call from a lawyer who is considering engaging you in connection with the matter, but that lawyer may not fully understand the specialized fields in which you work. So for the matter that they're coming to you, the lawyer may need a biochemist who has studied a specific particle or DNA or some very specified, a nuanced aspect of a field, and you may not have that required expertise. You may specialize in a different area of the field, and it's a good idea to be upfront with the lawyer and tell the lawyer that's not exactly what you do. I have a different area of expertise. The area of expertise that your case really is looking for is XYZ, and you can build goodwill by referring out the business to a colleague or someone else who you think would be well suited for that engagement. You also want to think about the fact that if you get engaged on this matter, you're going to be spending a lot of time with this lawyer. And if you have a bad feeling about the lawyer or the engagement or the way that person is running things, you may choose, for personal reasons, to pass on that engagement. Similarly, you may choose not to want to be associated with a particular product or company that's a party to the litigation. So you get that call, it looks like great work, you're going to be engaged to represent company X with respect to product Y. If you have any issues with respect to that product or that company, that may be another personal reason why you choose to pass on the assignment. And Ron, take over the next slide, please.
Okay. So this is just a list of the first questions you're going to be asked if you get on the witness stand, because when you're engaged, I would recommend you think about these questions in advance. This is sort of the test questions when you're put under the gun, and have to get past your name and your educational background. Think about what you're going to offer in your mind, because that's going to be whether or not it's going to be a good experience or a bad experience. I just tucked this away as a list of questions because these are my questions that I would be asking a witness when I come on witness stand first. I want you to be thinking about how you're going to answer them. So I would be handing this to my expert up front. Next slide, please. We're getting to the business here of being an expert. You're lucky enough, you're about to be retained. Some suggestions on your engagement agreement. You're probably going to be retained by a lawyer, not the client. Sometimes the in-house counsel will retain you, but often the lawyer will retain the expert on behalf of the client. It also helps with privileges with the court to show that you're working on a litigation. I encourage advances because, again, as I mentioned, there's always a possibility that you're not going to be used very much. An evergreen means to stay ahead of the client. The lawyer may be terrific, but the client may be slow in paying. If they lose the case, that could be another problem because the client may say, I don't want to pay any more money on this case after they paid all their fees. So I don't want the expert to get hurt. One thing important, no contingency fees. You want to be objective. You don't want to have an interest in the outcome of the case. So you'll get a third of whatever recovery it is. That is not cool. If you're on the witness stand, if that comes out, you want to be paid purely by the hour. Lawyers are probably going to ask for a budget and regular bills. And by the way, about getting paid up front and getting paid as you go, it's a good thing to do. You can tell a lawyer that because you may be asked on the witness stand, as I mentioned here, are you owed any money? And if the answer is no, that's a good answer because it suggests that your testimony doesn't have to be shaded because you're still trying to get paid. So that's some just general observation and thoughts on your engagement agreement. You will want to cover getting paid for travel and things like that. Next slide, please. This slide just goes into rates. It's outside the scope of this presentation to talk about expert rates, but they do vary. Some experts charge rates for a day because their entire day is killed if they have to go to court. Even if if it's 5-hour trial or 6-hour trial or 3-hour trial, you're still stuck in the courthouse all day. So they have a day rate for trials. They address travel time. You have to keep in mind what the competitors are charging, years experience. Again, as I mentioned, I'm going to keep mentioning, you don't want to be engaged just merely to conflict you out. Again, you want to get paid a good rate. Next slide. When you're drafting an engagement agreement, be careful. Don't put too much into it. It may be read by the adversary. You want to describe the scope of your engagement carefully so there are no surprises. You want to be, as I keep emphasizing, make sure you get paid. I guess I've had too many experiences or heard about too many experiences where experts might not have gotten paid if they did a really good job. So remember, the money's flowing through from the client to the lawyer to you, and that could take some time. So again, getting paid is very important. Because I know that experts work very hard, and I want to see them paid. Next slide, please. On billing, minimal details. I would try to avoid confidential information. Again, it's possible that your bills will wind up in the hands of the adversary. Expect that the invoice is going to be read by the attorney and the client. You want to be accurate because the lawyer on the other end of the phone usually knows how much time they spent talking to you. So if they think that if they clocked the phone call at half an hour and you put it down for an hour, that could be a problem. You don't want to mark up expenses. They should be charged through at cost. I often, in working with my experts and putting together their reports and their bills, look at clients. Lawyers are now faced with what's called outside counsel guidelines. I get guidelines from all my clients now with all kinds of details on what they'll pay for and what they won't pay for, and they flow through to experts often. So clients are much more reluctant these days paying for things like photocopying costs and faxes and things like that. So you need to know what you're going to be reimbursed for and not, and at what rates, etc. Next slide. This is the initial evaluation suggestions. You've engaged, you've got your billing set up. These are things that you're going to want to be thinking about as you get into the assignment. As I mentioned earlier, hopefully you didn't already reach an opinion, but you're going to be doing your homework to try to find out what happened. So you want to make a list. You want to find out what happened. You want to get a list of documents to read. You want to know who was involved. You may want to conduct interviews. And again, you're waiting to form your opinion. But in doing that, you want to put together a nice record that you can present to the other side as to what you did in a well-documented way to come to your conclusion. I do want to mention something about testing and reconstruction of accidents. Again, I can give you horror stories on accident reconstructions where they worked against us, where we thought a product would not fail and it failed, and then what am I going to do with that? So my only recommendation is before you do any kind of testing or accident reconstruction, you have a pretty good idea how it's going to come out. This is not an experiment, because your tests and you're going to have to keep a record of what you did, and it's being closely examined, and it's going to be picked apart as to whether or not the reconstruction you did was similar to the event itself. In terms of notes, I say be very careful. I always talk about the New York Times test. Don't write anything embarrassing that you'd not want to see on the page. New York Times, so be very sparing in your notes, and don't just put down things that you would not want to see read to a jury. Next slide. This is we take many depositions in cases with lengthy transcripts, and lawyers often will summarize those transcripts and offer the expert a summary to read, rather than having the expert spend hundreds of hours reading lengthy transcripts, which makes sense. The problem is that the adversary is going to say that the expert only was spoon-fed the facts and didn't have a chance to look at all the testimony. So what I do is I give my experts transcripts where I give them the full transcript, but I highlight for them certain sections or point out that they should read. So I would avoid just getting simple summaries. I would ask for the full transcripts, even though you may not spend a lot of time reading them. So you're not accused of having a biased sense of the facts. If you conduct interviews, I make sure that an attorney is present. That will help you later if you want to try to protect the interview as privileged. If you're at a site where the adversary may be present, be careful what you say. Try not to point out evidence to when the adversary is standing there, and try to keep your poker face. Just take notes and just walk around and look at what happened. Use accredited certified labs if you're doing any tests. I'm now going to ask Leah to cover the next slides.
So there are common tools as you get into the weeds of the litigation in what we call discovery, where the parties exchange all the documents and communications that could be relevant to the underlying dispute. So I'm just going to quickly give a very high-level description of these 4 discovery tools. Interrogatories are a set of questions that are issued by either side in litigation to the other side that asks the other side, and the adversary is required to supply specific answers to that set of questions. So you have a litigation is commenced by what's called a complaint, a pleading. But oftentimes that pleading might give a general story of what the claimant contends happened, but doesn't develop all the facts or develop all the underlying issues that you want to really flesh out in discovery. So interrogatories are an opportunity to ask more particularized questions and flesh out the issues for the litigation in advance of trial. Document requests are a request for production of relevant documents, communications, or evidence that could be in any way relevant to your case. So oftentimes today, especially in this email age where everything is recorded, document requests ask for everything that can talk, any kind of communication or document that goes to the dispute. The document request gets issued. The opposing side has to respond. They issue responses. They may object to some of the requests on the basis of privilege or other bases, but typically there's an extensive part of litigation, which is exchange of discovery, including exchange of documents. Request for admission is similar to interrogatory, but different. The request for admission, the way it's fashioned is you have a set of declarative statements that are issued by one side to the other side, and the other side has to respond, the adversary has to respond to that set of statements with, we admit that statement, we deny that statement, or give a basis for why they can't or admit or deny it. So this is a way, oftentimes as discovery is coming to a close, there's always a deadline for all of these things, but to narrow the issues and get almost like stipulated set of facts that the parties agree happened, you can do that oftentimes through a request for admissions. Finally, depositions. A deposition is an oral examination conducted before trial. The person being deposed at the deposition, the deponent, is asked a series of questions. They get a notice to show up at this time and place. Usually parties are courteous and it can be, schedules can be worked out if you're traveling or away on business or have some other reason you can't make it on a particular date. Usually you can work that out. And oftentimes the most desired witness for deposition is, the parties to the case, but depending on the jurisdiction, the expert may be called to give a deposition, and the deposition is a recorded exchange. So there's going to be a stenographer, sometimes even a videographer present, recording everything that is said at the deposition. Next slide, please. If you're involved in a matter that requires a formal written report, you're going to be asked to prepare one. And in your written opinion, will have to provide support for that opinion. It can't just be like a one-liner, something that we call a net opinion. You just conclude that and here it is, here's my opinion. You need to lay out in detail all the steps, all the analysis that you took, and all the support that helped you arrive at that conclusion, at that opinion. The standard for issuing an opinion is a reasonable degree of certainty, professional certainty. And you don't have to be 100% positive, but you need to be able to opine that you've reached this conclusion and to a reasonable degree of certainty. You should be also, when you're preparing your written opinion, be prepared to address the other side's opinions and what you can expect them to opine, and you want to sort of get ahead of that and think about what position they're going to take and address that as well. Depending on what jurisdiction you're in, where you're litigating, there's usually a fairly specific set of items that have to be included in your report, and obviously the attorney that you're working with is going to help you, and you should ask if there are any particulars like your rate and your experience and your CV and all the discovery that you relied on. That's just a small set of what's going to have to be in your report, but you want to make sure to get that information from the attorney you're working with. Next slide, please. Very importantly, your report should be a work of your own. You don't want to have the attorney write it for you and then just rubber stamp it. Like I said earlier, it's an opinion that you reach based on analysis, investigation, research, industry standards. So you want to really back it up with strong support. Very important, mark your drafts as a draft. Parties will always try to get as much discovery as they can. It may be discoverable. You want to mark it as a draft. So, and as it's exchanged with the attorney, it's going to be hopefully be work product. Generally, under the rules, the communications with an expert can be privileged, but you just want to make sure that you observe the guidance of the attorney you're working with respect to keeping the privilege and marking things as draft, and keeping the communications with the client, the party, have the attorney always copied on it, etc. And finally, a very important sort of pointer, your opinion, to the extent that you learn more facts and your drafts change over time. You never want to say that your opinion changed. It's just that your opinion has evolved based on whatever new facts you received or further analysis or further investigation, etc. So that's really just the semantics of it, but your opinion is evolving rather than changing, because that can be a hard thing to support when you get cross-examined. Next slide, please. Here you just have, tips that I think we covered throughout the course of the presentation today. You don't want things to get overly complicated. Ron referred to earlier, you want to be likable and you want to be able to explain complicated things in a way that is digestible to non-experts in that area, because that's really what you're there for. Ron,
So
take it away. Next slide, please.
Putting together this presentation, we thought we would take you up to the position of the report. There are 10 more slides, but they really go into your testimony at trial, which you can read at your leisure. This is if you ever get to the point where you're actually testifying. Some tips I give clients, and I'm sure you'll be working with a lawyer before you get on a witness stand, and I would of course defer to whatever lawyer you're working with on how they want you to present yourself. But the final slides are, and again I encourage you to look at them, deal with my thoughts on demeanor and presentation. It's just that I want crisp, positive witnesses who come across, as I said earlier, as good teachers, who are not easily rattled, who can go with the flow, and are able to sort of gauge their adversary. And that comes with experience. And hopefully everyone on this call will get some experience. And one of the thoughts is for a future presentation to have a boot camp on just for those who are actually going to be testifying, to help prepare them for their testimony. That is done better, not through a webinar, but through an one-on-one. So I encourage you at your leisure to read the last slides, and I thank you for your questions. You're welcome. You have our email information at the end for contacting us if you'd like. We're happy to answer any questions, and we hope that you found this webinar helpful, and we enjoyed spending the hour with you. So thank you very much.
Ron and Leah, thank you so much for a great presentation. As it is closing in on an hour, we have time for just one additional question. And that is, how would you handle the expert witness from the other side who lied or stretched the truth?
That's really a question for the lawyer to answer. It's not really an expert. What I do is I usually will wait until the most opportune moment to bring that out, because if I bring out, there are a couple of places where you will be encountering that expert one-on-one. So I pretend I'm the lawyer for a defendant, and the plaintiff's expert lied, and I know they lied about something. They destroyed evidence, or that they misrepresented their past background or something. They were sanctioned. The question is, when are you going to bring that out? If I bring that out too early, the other side's going to drop that expert. So the way the process works is that you have to identify your experts by a certain deadline, and then you're kind of locked in, and it's very, very hard to get a new expert. So I'm going to wait until that expert is locked in. I might actually wait until they're on the witness stand to bring it out. I'm not going to bring it out when I first do a discovery deposition of the expert. So that's how I'd handle it. I'd bring it out and spring it on them, just like Perry Mason. So that's how I would deal with it.
All right, great. Well, thank you very much, and thank you to everyone in the audience. It's been a fantastic presentation. If you do have additional questions, you'll see Ron's contact information, and we appreciate you joining us. Our next webinar focusing on dietary supplement GMPs is tomorrow at 1 o'clock Eastern, and if you have not registered, we would hope to see you there. And thank you again. Have a great afternoon, everyone.